Welcome back to Keepers of Liberty, where we explore the principles that preserve freedom and truth that shaped our nation. To review, in our first session, we discussed how every person sees the world through a unique lens, a worldview, if you will. It's like a pair of glasses that colors how we interpret everything around us. From daily decisions to the foundations of law and government, our worldview matters. Now, in American legal thought, two major worldviews compete for influence. And when I say two, there's probably, 100 different derivatives of each one of these. But, for our purposes, there are two major worldviews that are competing for influence in American legal thought. The first perspective is the inalienable Christian worldview, which sees God as the source of law and rights. Inalienable is that word that goes all the way back to our Declaration. And that word inalienable refers to rights or attributes that cannot be taken away by any government authority. They can't be transferred. They can't be surrendered. These are considered inherent to every human being by virtue of their existence as being made in the image of God. In American legal philosophical tradition, especially as expressed in our Declaration of Independence, inalienable rights, they're understood to be granted by the Creator, by Creator God, and they include life and liberty in the pursuit of happiness. And because they're not granted by the government, because they're not given to you by the government, they cannot be legitimately removed by it. Now, the second perspective is the alienable secular humanist worldview. And, not unalienable, but alienable. That alienable secular human view sees humans as the creators of all law and the deciders of all law and all liberty. What liberty you have doesn't come from God, but whoever happens to be holding power for the day will decide whether or not you will have a liberty or not. And the founders of the United States and the framers of our Constitution, they largely embraced the unalienable worldview, that objective, unalienable worldview, that worldview that says you can't take away our rights. And they come from God. They understood that laws ought to reflect divine or natural law, objective truths that exist outside of human opinion. Go way back to the thinkers like Sir Edwin Cook and Sir William Blackstone. They taught that God's law is written on the human heart and discoverable through reason. They didn't say that reason wasn't important, but they said reason apart from God's law, not a good thing. This belief grounded the idea that human dignity is sacred and that liberty is a God-given right, not a government-granted privilege. Now contrast that to the alienable worldview. The alienable worldview sees law as a human invention, always evolving. Think of Darwin and his, evolution. The alienable worldview sees law as a human invention, always evolving, always subjective, never objective, and it's always shaped by those who are holding power. Here, those in power can redefine rights, or they can revoke rights based on what their personal preferences are with regard to society at the time, without any reference to any higher moral standard. Now, worldview shifts in a country have profound implications. If there's no objective truth or good, then law becomes a tool of those holding power rather than a reflection of justice. As G.K. Chesterton warned, modern ideals like liberty and progress can become ways to avoid asking the deeper question of what is good. The inalienable worldview insists that good government is a moral government rooted in unchanging truths. The inalienable worldview says that good government is a moral government rooted in unchanging truths. It holds that we must measure laws against a higher standard, not just the opinions of judges or politicians holding power. I like to read legal scholars, and one legal scholar, my favorite one was Herb Titus. And he said, without an objective standard outside of man, we cannot know whether a law is truly just. Wow, how profound is that? Relativism, on the other hand, at its very core, denies fixed points of truth. And yet, ironically, it often claims that its own views are universally valid. And that is a contradiction that undermines its own foundation. Now, I can tell you how many times I've debated professors, and they will talk about how relativism is, something that is what we do now in academia, as opposed to having the idea of a moral objective truth. That has to be an ancient, archaic way of thinking. Yet they believe that their relativism is objectively true. So it's kind of funny how they don't hold themselves to the same standard that they try to play on everybody else. And so what's at stake? Whether we view liberty as unalienable or alienable determines how we govern, how we protect rights, and how we define justice. In the very end, the American legal tradition invites us not to ask just what is legal, but what is right. And that question begins with the worldview through which we see the world. And so in this session, we take a deep dive into Article 3 of the Constitution and the judicial power. Article 3 says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress from time to time ordain and establish. This part of the American Constitution creates the U.S. Supreme Court. It allows Congress to create lower federal courts, and it provides that judges and justices on the Supreme Court hold their office during good behavior. And that, folks, has been interpreted, for better or worse, to mean lifetime tenure unless they're impeached. So judges under Article 3 shall receive compensation which cannot be diminished during their time in office. And the reason that the framers of the Constitution put that in there is they were foreseeing a federal judiciary that would not be political, and they did not want to have any kind of political influence that would interfere with their ability to just look at the law and decide cases based on the law and just the law. And so they didn't want some future Congress to threaten to lower the salaries of judges and then create a conflict for the judge to either follow the law or maybe, follow the money. And so our framers were doing everything they could to create an independent judiciary, but an independent judiciary under Article 3 comes with some responsibility. And that responsibility is to say what the law is, not what you prefer it to be. So note that the power that Congress holds here to check the federal judiciary, though, while we give the judiciary independence, we also set it up so that the judiciary cannot abuse its power. And so Congress is given power here as a check on the federal judiciary. Other than the Supreme Court, Congress gets to determine whether or not to establish federal trial and appellate courts. That includes the power of jurisdiction stripping. And what do I mean by that? Well, if Congress can completely eliminate a court or decide that there shouldn't be a court, then certainly Congress can decide that there are certain issues that the lower courts ought not be able to hear. And so these are very, very effective limitations, if you will, on the exercise of government power that I'm guessing not too many federal judges these days have thought about in a while. Keep this check in mind as we discuss how some of the judiciary, and when I say some of the judiciary, I'm talking about judicially active, folks who have an alienable worldview, who don't want to follow the law, and they want to rewrite the law themselves, even though nobody elected them. Keep this check in mind as we discuss how some of those kind of judges in the judiciary sometimes use an alienable worldview in ways that could exceed the authority granted to the judiciary under Article 3. Section 2 of the judicial power talks about the judicial power extending to all cases and law and equity arising under the Constitution and laws of the United States, also cases involving treaties and a variety of other areas. And so this is really, really interesting because what we're talking about here is jurisdiction of the court. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties. This section is really outlining the scope of federal judicial power. And that's limited to cases arising under the Constitution and laws of the United States, for example. And so what you cannot do, say if you're some law professor and you really have got this complicated question on constitutional law and you'd really like the federal courts to, answer that question for you. You can't just go in and, say, hey, judge, I'm a law professor. I'd like you to decide this question on the Constitution or the laws. You actually have to have a case in controversy. There has to be an injury. That's called the doctrine of standing. You don't get to stand in the court. You don't get to come into the court unless you have a real case where you have been harmed, where somebody's been harmed. Why? Because when you have a case where somebody's been harmed, think of an animal that's been injured. That animal that's been injured fights hard. And so if you have a real case between two parties that are adversaries, they're going to fight real hard. If they fight real hard, then the idea is that truth will emerge, as opposed to if you're just seeking an advisory opinion or you would just like some kind of hypothetical answered, there's not that vigorous fight that leads to the emergence of truth and hopefully justice. And so you've got this section of Article 3 that is outlining the scope of the federal judicial power that's talking about cases arising under the Constitution laws of the United States, treaty-related cases, disputes involving ambassadors and folks that are diplomats, cases that involved admiralty and the maritime jurisdiction, controversies involving the U.S. government, or a dispute. Sometimes there's a dispute between the states, Ohio and Michigan, or Rhode Island and Massachusetts may have some disputes with each other. At one time, Michigan and Ohio had a border dispute on what the border was. These are the kind of questions that the U.S. Supreme Court has jurisdiction over. So it also, in Article 3, we learned that the Supreme Court has what's called original jurisdiction in a very narrow kind of cases. And when we say original jurisdiction, that means they actually hear a trial. It's actually a case of first instance. It's not brought at the lower U.S. District Court or at the Court of Appeals, but it's actually brought in as a matter of original jurisdiction in the Supreme Court. And these are cases involving ambassadors of another nation or where a state is a party. And so in all other cases, we learned that we the people in Article 3, through Congress creating the appellate courts, they say all other cases, the Supreme Court has appellate jurisdiction, which means that when Congress created these lower courts, the U.S. District Courts, the U.S. Courts of Appeals, that as a case in controversy arises through the federal court system, when it gets to the Supreme Court, the Supreme Court has what's called appellate jurisdiction. They can hear an appeal from the U.S. Court of Appeals. Now, they don't have to hear, and so it's called a petition for writ of certiorari, for example. And somebody would have to file a petition in the Supreme Court asking the Supreme Court to hear this federal case as a part of their appellate jurisdiction. So the last thing that we're talking about today with regard to Article 3 is that it guarantees a trial by jury for all crimes except for impeachment, and that these trials shall be held in the state where the crime was committed. So that's why you have these federal district courts all throughout the United States, but they're within the state. If you commit a federal crime in the state of Michigan, you will likely be tried in the Western District of Michigan or the Eastern District of Michigan. If you commit a crime in the state of Florida, you will be in a federal court, not a state court in Florida. It may be the Northern District of Florida. It may be the Middle District of Florida. It may be the Southern District of Florida. What I want to do now is move from the actual jurisdiction in Article 3 and talk about constitutional interpretation, because we have a real big deal these days with people arguing that the courts are being weaponized and that there are judges that are using their power to actively change the Constitution, without following the Constitution. And there's a whole lot of scholarship out there, I will tell you. Law professors have been writing for way, way too much, in my view, about all the different approaches to judicial interpretation. In what I'm going to suggest in this talk here is that judicial interpretation we're going to get to, and we're going to talk about that, but underlying judicial interpretation is the worldview of the judge, is the perspective of the judge. Because if you have an unalienable worldview, that's going to lead you to a very, very different kind of approach to interpreting the Constitution than if you have an alienable worldview where it's very subjective and you decide that you have the power to decide what is right and wrong, as opposed to the Constitution itself. And so in deciding cases arising under the Constitution and laws of the United States, judges interpret the Constitution using different worldviews. And that leads to them using very different approaches to interpreting the Constitution. And so to begin this discussion, we might ask, what does it mean to interpret the Constitution? And why do judges sometimes reach such different conclusions from the same words? Well, the answer, I think, lies in something deeper than legal training. It, again, lies in worldview. And as we talked about in the introductory session, a worldview is the lens through which we interpret reality. In constitutional law, it shapes how judges and lawmakers understand the very meaning of liberty, of justice, and of rights. And the worldview through which authorities view the Constitution often determines the choice of the interpretive approach that they use, as well, I'm going to say, as how the judge or the lawmaker applies it in any given case in front of them. And so for those informed by an objective, unalienable worldview, the Constitution's not just a set of guidelines. It is the framework on which the government and our legal system are constructed. Its words both create the U.S. Supreme Court's authority, give it definition. Those words were written quite clearly by highly qualified draftsmen, by our framers, to express a very simple meaning. Faithful adherence to those words is the touchstone for measuring the fulfillment of the court's sacred duty to resolve disputes arising under the Constitution and laws of the United States. Every justice who takes an oath of office swears to uphold the Constitution as it's written, not as he or she would like it to be written. And so discerning and applying the meaning that the drafters embodied in the Constitution's language is the Supreme Court's high calling. And they should look at it as a high calling. The alternative of making those words mean whatever contemporary judges think they should now mean is the first step in the path to tyranny. And this is where a judge's worldview choice becomes relevant. It's a question, are we going to be objective or are we going to have a subjective approach? In the American constitutional tradition, two competing jurisprudential paradigms, oh wow, those are a couple of big words, legal philosophical approaches help us understand the law. And so the first is known in legal circles as originalism, often aligned with objective plain meaning interpretation. What's the plain meaning of the words in the Constitution? That's the one approach, originalism, plain meaning originalism, we'll call it. And the other one is judicially active, organic, or living constitutional philosophy. That tends to embrace a subjective, evolving notion of constitutional meaning. And when I say evolving, whoever's wearing the robe says, I get to evolve it the way I'd like it to be. Let's start with the objective, plain meaning originalism. That's a kind of approach to interpretation that is anchored in inalienable rights. Originalism, especially its variant rooted in the plain meaning of the words, kind of originalism, it grounds itself in the idea that the constitutional text has a fixed, knowable meaning at the time that it was written. This approach is very straightforward. It presumes that legal interpretation is constrained by objective language. It's constrained and limited by textual clarity and historical context. It reflects the inalienable worldview. Why? Because it's grounded in natural law theory, theistic theory. Here, law is discoverable. It's not invented. It exists outside and prior to a judge's personal political preferences. And this originalist approach presupposes that rights such as life and liberty and property are unalienable, inherent in persons by virtue of their human nature and the fact that they're made in the very image of God. They're not conferred by somebody holding power. So what does that mean? It means that the judiciary's role is not to be out there reshaping law to fit a judge's personal preferences for evolving societal values in the way the judge thinks it should be. Rather, it's to faithfully apply pre-existing legal meaning and protect these permanent rights from government infringement. In this light, got a lot of light in this studio here. And when you shine light on something, it becomes much clearer. And in this light, originalism is judicial decision-making with restraint. It seeks to protect individual liberty by limiting the discretion of the interpreters, the judges. Here, the judge's role is more a neutral arbiter rather than the politically driven legislator. And we see too many, in my view, judicially active judges who are playing legislator instead of merely serving the role that the Constitution has them assigned to, which is to decide cases and controversies arising under the Constitution. So let's talk for a moment about this subjective, so-called organic, living constitutional approach to interpreting the Constitution. It's an escalation, in my view, of the alienable legal philosophy. You know, this organic or living constitutionalism adopts a very subjective, evolving again framework for interpreting legal texts. Here, the Constitution is not considered a fixed compact, but it's supposedly some kind of living document. Like all of a sudden, this has a beating heart or something. Where the judge is going to say that meaning is malleable. I can change meaning whenever I want to. Malleable in meaning according to the personal political preferences of a judge's shifting cultural, political, or philosophical views. And that is dangerous, whether it's a conservative or a left-leaning cultural, political, or philosophical view. And that reflects the alienable worldview, folks, where rights are understood as products of the personal political preference of those holding power, subject to revision, subject to a little judicial activism wherever we need it, subject to redefinition when we want it to be, or reallocation, based on the judge's personal preferences. Under this model of judicial interpretation, the unelected and politically unaccountable judge becomes an active agent of so-called progress. They go, they put a robe on, they create new meanings to align with the societal preference that they personally have, and they go home and they call it the rule of law when it's anything but the rule of law. It's the rule by judges. Using an organic, living constitution, legal philosophy, judicially active legal philosophy, undergirded by this alienable worldview, the government, by way of an unelected judiciary, becomes the source and decider of what your rights are, of what your liberty is, what liberty you will have and what liberty they will take away from you. We will give you the liberty of same-sex marriage. We'll give you the liberty of abortion. We'll take away your right to protect yourself and to bear arms. We'll take away your right of religious conscience. We'll take away the liberty of free speech. Judges using this organic, living constitutional approach to the law and jurisprudence, or legal philosophical approach to their decision-making, they, in my view, arrogantly presume a supposedly constitutional role as the author of legal meaning. They're not the author of legal meaning. They contend they are because they've got a robe on, but they're not. The Constitution and the people's laws, that's the rule of law. Here, judicial interpretation is not confined by any objective historical anchors, but instead it's being used by the judge to implement that judge's own personal political preferences as construed in the present moment. Well, folks, if you haven't realized it already, these worldviews are colliding. These competing frameworks, originalism as objective plain meaning of what the words mean versus the living, organic, subjective, evolving meaning approach to interpreting the Constitution, or the words in the Constitution, they're not merely some kind of academic disagreement. They're undergirded by profoundly different philosophical and cultural presuppositions. Originalism aligns with the inalienable worldview that posits, that suggests that there is an objective moral order. We can access that objective moral order through reason. God has given us the ability to reason. We can assess it through reason, know that it's historically situated and theologically sound and grounded. It holds that law and justice have a meaning outside of us. There's a standard outside that we can look to for good and bad, right and wrong, just and unjust. In contrast, the so-called organic living constitutionalism, that subjective approach, reflects an alienable worldview that regards moral and legal meaning as fluid, emerging from one's own evolving reasoning, apart from God, apart from truth, where rights are alienable. That means they can be given away or taken away from you. Where rights are flexible, where they're depending on an ever-changing human self-definition of the person wearing the robe. This contrast between the unalienable and the alienable worldview is reflected directly in judicial decision-making. Well, the one thing we can be sure of is that legal philosophical approaches to interpreting the Constitution is never neutral. A judge's choice of legal philosophy or jurisprudence expresses an underlying worldview commitment. Whether a judge adheres to the plain meaning of the constitutional text or to an evolving, personally preferred societal construction, that underlying presumption about the nature of law, of rights, of human person profoundly impacts the outcome. And it clearly determines which approach the judge is going to use to say what the law means in the Constitution. And to understand and defend inalienable rights in a constitutional government, one has to embrace not only the content of those rights, but the legal philosophical framework that acknowledges their objective enduring authority. They were here and they came from God from the beginning of time, and they will be here until Jesus returns. Anything less subjects liberty to the whims of those who happen to wield interpretive power at the moment, whoever has the robe on at the time. At the heart of the clash between the two legal philosophical worldviews in America and the debate over approaches to interpreting the Constitution are questions involving the scope of the Constitution's provisions. So, for example, in the First Amendment, what does the prohibition that Congress shall make no law respecting the establishment of religion or the free exercise thereof mean? When interpreting the scope of the Constitution's provisions, another key issue is whether or not the court will determine that a life or liberty interest should receive constitutional fundamental right status. And what do I mean by that? Sometimes the court says that, okay, look, we've got the Bill of Rights here. We've got freedom of speech. We've got the free exercise of religious conscience. We've got the right to due process. And we've got these, what are called, the court calls fundamental rights. Now, from time to time, the court has added to that list that's in the Bill of Rights, beyond freedom of speech, beyond the free exercise of religious conscience. And all of a sudden you get, another right that's considered a really important right that limits the ability of government to interfere with the right, things like abortion, same-sex marriage, and even maybe the fundamental right of a parent to control the upbringing of a child. And that is a fundamental right that has been recognized by the court for over 100 years. You don't see those words in the Constitution, but what the court did is they said the liberty protected in the 14th Amendment, where the states shall not deprive somebody of liberty without due process, they said, well, it says due process, and they are talking about procedure, things like, fair trial, a lawyer, and right to appeal, things like that, procedures. But they created this crazy doctrine called substantive due process, and it sounds like an oxymoron because it is. How can something that is supposed to be about process all of a sudden be about the substance? Well, it's about the substance if you want to evolve it to mean that I, as a judge, can add something to the Constitution. And so that's how we get abortion as a considered a fundamental right, like freedom of speech, or same-sex marriage considered a fundamental right, like free exercise of religion. And so when interpreting the scope of the Constitution's provision, one of the things the court has to do is to ask the question, what life and liberty interests ought to get this high-level fundamental right status? Well, we know that the unalienable rights, freedom of speech, free exercise of religious conscience, those ought to be, considered fundamental rights. And again, why is it important to be something, a fundamental right versus something that's not? Well, if the court deems it to be an unalienable fundamental right, then when a question comes in front of them involving that fundamental right, where you've got a government action, a government authority using its power to interfere with that right, what the court does is the court brings out I call it a Supreme Court microscope, to look very closely at the government action interfering with the right. And then they hold the government to the highest standard under the law to justify their substantial interference with what has been deemed to be a fundamental right. Now, if the court has not deemed something to be a fundamental right, then guess what? They don't bring out that Supreme Court microscope, and the government can interfere with whatever your liberty is as long as they have a legitimate reason for doing so. They don't have to have this high, compelling reason of the highest order to do so. And so you stop right there and you say, okay, I begin to see why worldview really matters, because my worldview is going to lead me to the approach that I take to interpreting the Constitution. And if I've got an approach that says I get to make it up, it's all about me and my personal autonomy and my identity, I can decide that I'm going to add a right to the Constitution like same-sex marriage. On the other hand, if my approach is that no, I'm going to recognize that objective truth exists and that for something to be an inalienable fundamental right, it has to be deeply rooted in the history and tradition of the nation, I can perhaps see that we'll talk about the fundamental right of a parent to control the upbringing of a child, that kind of right ought to be a fundamental right because it was deeply rooted in the historical, legal, and common law traditions that were adopted by our framers when the Constitution came into force in 1787. When interpreting the scope of the Constitution's provisions, one of the key issues is what life or liberty interest should receive constitutional fundamental right status. And to make this determination, sometimes the U.S. Supreme Court uses an originalist, plain meaning approach. In doing so, it looks to whether the liberty at issue is part of the deeply rooted historical, cultural, and legal traditions of the nation. And when the Supreme Court of the United States recognizes a liberty interest as fundamental, again, it generally requires the government to provide a compelling interest of the highest order to justify interference with that right. And the court, while applying this strict scrutiny to government action, it further requires the government to show that it's using the least restrictive means available to accomplish this very high, compelling purpose. Folks, think about that. How many government actions interfering with liberty do you think survive that kind of scrutiny? Not very many. That's why it's called a fundamental unalienable right. And now you begin to see how important it is that you have the right legal philosophical approach to saying what the Constitution is, because if you've got the approach that says I get to make it up, all of a sudden you've got judges that are adding stuff to the Constitution just because it's part of their personal political preference. That's a very strict test that the court applies when the government interferes with a fundamental right. This strict test provides a great deal of protection for whatever is considered an inalienable fundamental right. And whether a right receives constitutional designation as a fundamental right, again, depends on the worldview through which a judge or lawmaker views the Constitution. And we're going to talk about how they got to abortion. We're going to talk about how they got to same-sex marriage. And we're going to talk about how they got to a fundamental right of a parent to control and direct the religious upbringing of a child. Informed through the objective lens of the unalienable worldview, one is going to discover the divinely revealed, naturally existing, unalienable life and liberty rights by way of an originalist plain meaning interpretation. That's exactly why it matters what your worldview is, because your worldview is going to take you to the kind of approach that you have when you are saying what the words of the Constitution mean. And these are basic objective standards which, when reflected in the Constitution by the framers of that document, one can use to objectively measure whether government action is right or wrong again, good or bad, just or unjust, and ultimately whether it's constitutional. These are our unalienable rights. And these unalienable rights in a constitutional sense are, because of their unalienable significance, often considered fundamental rights that get that higher level of scrutiny when the government tries to interfere with it. And again, those who see the Constitution informed by the objective, unalienable worldview, they believe that judges ought to act with restraint when interpreting the Constitution. In other words, when I say restraint when interpreting the Constitution, that means just merely saying what the words are and what they plainly mean, not adding to what they want it to mean. Their originalist interpretive approach is likely to reflect deference to the framers' objective standards that they actually enshrined in the Constitution. They're going to go to the Constitution. They're going to go to the Word. What did it mean? What did it mean when it was written? What was the context in what was written? So we can figure out what it actually means, because that truth will be the same today as it was then. And if it needs changing, well, there's an amending process provided for in the Constitution that doesn't involve judges at all, but involves the people. So in determining whether a fundamental liberty exists, should abortion be a fundamental liberty? Should same-sex marriage be a fundamental liberty? Should freedom of speech be a fundamental liberty? Should the free exercise of religious conscience be a fundamental liberty? In determining whether a fundamental liberty exists, these judges stringently limit the exercise of their power of judicial review to what is actually in the Constitution. And this limited judicial review seeks evidence of what did the framers originally mean when they wrote it? What was their original intent of the actual text? And what is the deeply rooted historical, cultural, and legal traditions of the nation say about those words? So here, the inalienable liberty interest recognized by the framers, they generally receive constitutional status as a fundamental right. Things like freedom of religion, freedom of speech, but not things like abortion or same-sex marriage, because you literally can't find it anywhere in the Constitution, those latter things. Judges using the unalienable worldview lens, that, remember the glasses that we had in an earlier session? The judges using the unalienable worldview lens, they especially recognize an inalienable right as a constitutionally protected fundamental liberty interest if the framers expressly listed it in the Constitution. And so because the framers listed things like freedom of speech and the free exercise of religious conscience in the Constitution, that liberty interest of us as a citizen is something the court seeks to protect. And it protects it by holding any government action that interferes with it to a very, very high standard, where the government has to have the highest level of justification under the law before it can even think about interfering with one of our fundamental inalienable rights. Because of the unalienable nature of a fundamental right, it serves as a sacred, inviolable, objective standard that government can look to know where that's a bridge too far. You cannot cross it. You cannot interfere with freedom of speech. You cannot interfere with freedom of religious conscience. Using this objective standard, a judge can measure, without resorting to any subjective opinion, any subjective human opinion, if you will, whether or not that law or government action is constitutional. They can just look to the standard. Congress shall make no law respecting the establishment of religion or the free exercise thereof. You can't interfere with freedom of speech. Well, if government writes a law that interferes with religious speech, you see, wow, the government is going to run right up smack against that objective standard that says you can't do that. And the court's job is to protect that liberty that's objectively put into the Constitution. The objective constitutional legal philosophy of originalism, grounded in those deeply rooted historical, cultural, and legal traditions, that you're going to see collides with the subjective, alienable worldview, rejecting that sacred, inviolable standard. Judges wanting to have truth be malleable, it can be subjective. And so judges using this subjective, organic interpretation by way of their alienable worldview, I can change it whenever I want to, they wrongly, in my view, see the Constitution as an evolving organism, the meaning of which they believe their office empowers them to actively manipulate. They become tyrants, ruling by judicial fiat. They're unbound by the constraints of the Constitution's actual language, because it's up to me. I can decide what I want it to mean today, and then I'll change that tomorrow if I feel like it. The alienable worldview lens enables judges to see the Constitution as a living, evolving organism, making meaning malleable, making meaning, so flexible and fluid without any sense of constitutional self-control. and contending that their special training in the law deems them worthy of actively adjusting the meaning of the Constitution, these judicially active judges gaze into what they call jurisprudential penumbras. And there's a Harvard term for you. Into jurisprudential penumbras to subjectively fashion fundamental liberty interests that they personally believe require judicial protection from expressions of the people's will. I've actually heard judges say that. I've heard a federal judge in an elevator. I was talking to him one time. He said, there are just some things that are too important for the people to decide. The arrogance of that kind of approach is nothing less than the first step down the road to tyranny. And it's also the way that we get the right to abortion, the right to self-identity and one's gender, etc. Proponents of this very malleable, subjective, organic judicial policy-making approach say that unelected judges are entitled to personally evaluate whether their evolving societal customs, and I say their evolving societal customs because it's in their mind, whether that evolving societal custom justifies the judge deeming an interest to be a fundamental liberty because it's implicit in the concept of ordered liberty, they say. What is implicit in the concept of ordered liberty, except in the mind of the judge who's deeming it to be some kind of special right because the judge wants it to be so? And when the judge says, yes, it should be so, the judge judicially anoints the interest with fundamental right status. And all of a sudden, it's just like freedom of speech that's actually in the Constitution that we, the people, put in there. And now it's got to be treated just like free exercise of religion that we, the people, put in the Constitution because the judge has now added it to the Constitution. A judge, by the way, that is not politically accountable to anybody. And with no objective moral standard as a measure, law and liberty become whatever a judge wants it to be at any given situation on any given day. And the absence of accountability here is consistent with let's talk in Darwinian terms. It's consistent with a survival of the fittest philosophy of power. And I'd like to pause maybe for a moment and observe that the immense legal philosophical impact of what's happening here. One of the founding principles of the United States is that we're a nation of laws and not of men. And that principle is known as the rule of law. And under the rule of law, no person, not even a king, was above the law. And so the rule of law for the American nation is its Constitution, enumerating powers granted to the government by we the people, and including the inalienable rights limiting the exercise of that power that we've given the government. Both conservative and liberal judges not wanting to be limited by the rule of law, at least in the traditional unalienable sense, they resort to that alienable worldview approach. And doing so allows them to recharacterize the rule of law to include rule by judges, because I've got a robe on. And when used by a non-politically accountable judiciary, politically accountable to nobody, folks, the evolving, morally relative, alienable worldview, that temptingly provides an instrument to diminish the unalienable rights and other invaluable standards of some of the citizens, while creating new rights to advance the political interest of other citizens. And all this occurs within a worldview that permits itself to call its work the rule of law. I'm going to suggest that when you hear that, you need to say no, and check yourself very quickly, because it's not the rule of law, it's the rule by judges, the rule of judges. And such jurisprudential, such legal philosophical choices have consequences. And so, for example, human life being nothing more than chance byproduct of an evolving cosmic accident, that judicially ceases to hold inherent value worthy of dignity and respect. And likewise, judicially deeming sexual identity and the sexual identity ideology into some constitutional liberty of a fundamental right level, that diminishes, if not destroys, the free exercise of religious conscience and speech as a limit on the exercise of government power. And so many Americans, and especially those with positions informed by inviolable sacred principles. They see their unalienable liberty being eroded and taken away by those viewing the legal philosophical world through an alienable worldview. Increasingly, secular policy initiatives and judicial decisions strategically attack traditional unalienable truths concerning the origin of the universe, the sacredness of life, the marriage and family, freedom of speech, and the free exercise of religious conscience. And to Americans adhering to the framers' traditional objective, unalienable worldview, that evolution of those values, for example, to legitimize abortion or sexual ideology, is more aptly characterized as devolutionary social engineering. And that's exactly what it is in my view. And such a philosophical ideology ignores the truth that freedom requires responsibility. Without responsibility, freedom becomes a license to do whatever you want with no regard for others, which leads to bondage. The alienable worldview often seeks to reconfigure the political landscape to prevent citizens with viewpoints grounded in the sacred from even participating in the political process. And so for those legislators and for those judges informed by an unalienable worldview lens, God and His Word are real. We believe that He's real. He really is who He says He is, and therefore these things really matter. And we understand, therefore, that it's necessary to oppose devolutionary social engineering that are against God's tenets. And proponents of this subjective, alienable worldview presume that God and His self-evident truths do not even exist. They therefore contend that the viewpoints informed by such sacred sources have no place in their evolving constitutional governance. Because they have no place, participation in public policy debates is precluded if one's view of the world is informed by sacred principles. Since governments must only adopt public policy informed by secular dogma without regard to any sacred conscience or moral considerations. And so, folks, in America, we're in the midst of a collision of worldviews, especially under Article 3 of the Constitution and the judiciary here in the United States. Whether or not a judge will recognize and uphold unalienable rights against legislative action depends very much upon the legal philosophical worldview lens through which the judge views the Constitution. In the end, how we interpret the Constitution depends on how we see the world. Will we uphold the inalienable truths that shaped our nation, or trade them for an evolving personal preference of whoever happens to be wearing the robe? The choice is ours, and it begins with the lens through which we see the world.